Libel is simply a form of defamation. It's a written form rather than an oral form. But defamation, basically, traditionally, the state could punish someone for making a defamatory statement about another person if it was proved to be false, period. And then in 1964, New York Times versus Sullivan, the Supreme Court said that statements that are made about public figures or public officials or about government, even if they are false, an individual cannot be held liable for them unless the plaintiff or the government can prove that the speaker knew the statement was false or acted with reckless disregard for the truth. The idea was to say, we don't want to over-deter criticism. Criticism is important in our society. And people who know they're making a false statement that defends someone can be held liable for that. But someone who had reasonable grounds to believe that the statement was true cannot be held liable for that. And that was a major decision in the history of the First Amendment, in which the court basically made a radical change in when defamation can be subject of liability. A public figure means somebody who, even though not a government official or a politician, is someone who is widely known. And the reason for that is speech about people who are widely known, let's say an entertainer, even though it's not political, people have an interest in knowing about those people, and people who have become public figures have put themselves out into the public discourse and public debate in the way an ordinary person has not. And therefore, they've opened themselves up to being subject to criticism and the like, because they've basically put themselves out there as a public figure. But it's a line that's very tricky.